Good morning, everybody. I'm back again, and I'm your host, the Supreme Litigant. And before I begin, y'all already know the routine. If you haven't already, please hit that like and that subscription button. I'm going to give y'all a second to do that before I start back reading this ebook. All right, thank you. This will be part two. We left off yesterday, I want to say on page 7, I think. Yeah, I think it was page 7. I don't remember reading this yesterday. So we're going to start here. Today, y'all, I will, it'll probably be a little later today, but I'll go ahead and start sending out y'all copies of this ebook today. But it'll be a little later today. I'm sorry, I just be busy. Sometimes I don't be feeling like being bothered. I just be tired sometimes. So, that, just to let y'all know that. But let's jump right back into this. What we are doing now is learning that the doctrine is applicable when they're talking about this particular doctrine. If I'm not mistaken, they are talking about res judicata. The doctrine is applicable whenever there is an identity of claims and a final judgment on the merits. That means a disposition on the merits. And 3, identity or privity, or privity, or however you want to pronounce it. The central criterion in determining whether there is an identity of claims between the first and second adjudications is whether the two suits arise out of the same transactional nucleus of facts. Doesn't that sound just like double jeopardy to y'all? Sounds just like double jeopardy to me. But it's just, it's by another name. The only nucleus of facts between mother and father in a child support hearing is how much money the parties make. Fathers are even required to sign financial affidavits when child support is an issue, prying into their privacy without even making such a finding that a father is absent. The only issue in these hearings are the gross amount of such parties and which parent is the custodial and who is the non-custodial parent. A child support hearing does not involve and cannot even consider a custody determination. Thus, it cannot concern itself with property rights because they are reciprocal, although not the same thing with custody rights. As you read above in the case law. Okay, as you read above in the case law. I'm sorry about that, y'all. Sounds like I was reading another the same sentence. Well, no, another sentence. Anyway, then it follows that property rights and custody are separate issues, meaning if your challenge to a custody order is barred by res judicata, then the support order cannot be barred. And if the support order is barred by res judicata, then the custody proceeding cannot be barred. Why? Because a child support hearing does not involve nor consider custody determinations. It is a separate proceeding. Now, if a parent attempted challenge the custody order to say that the mother was unfit at the time of the custody award, then this would most likely be res judicata, because fitness to whom would have custody was an issue, not whether property rights / parental rights would be deprived due to any fault. This argument defeats res judicata and estoppel claims. Let me remind you, the reader, that no case precedents may exist on this issue specifically. However, on your search to find such authority, you may find exactly what I'm stating or start to see a deliberate foreclosure on this specific escape route. On the issue of child support, the entire nation knows that this defense to child support is unheard of, and to tell a parent who knows now what has been hidden that too bad, your loss is unjust. In no circumstance can a court today deny a claimant on a gotcha. To be quite frank, there is precedence on this injustice, even if res judicata and collateral estoppel applies, which we make a good argument that it does not. There is what is called and is a precedence across several states, the the manifest injustice exception. I've heard of that too. That's even applicable in so-called criminal cases. The court noted that where there that while there were let's see while there were no prior Florida cases applying this exception, several federal decisions and decisions from other state courts have held that the collateral estoppel doctrine does contain a manifest injustice exception. We hold that collateral estoppel will not be invoked to bar relief where its application would result in manifest injustice. This looks like a bankruptcy court uh, opinion. Res judicata will not be invoked. Res judicata will not be invoked where it would work an injustice. Res judicata should not be rigidly applied to defeat the ends of justice. Can you think of any more important reason that the doctrine of manifest injustice should apply to res judicata defenses against claims that a father were deprived of the value of services through no fault of his own, thus child support should be terminated because he could have used those defenses prior but didn't? Take the parent who states that at the time of the establishment of the support order that he was not an absent parent, did not abandon his child, nor willingly and knowingly gave up parental power voluntarily, but was instead pursuing said parental responsibility over the objection of the other parent, who had no reason to keep the child away, and the child support order is purely a retaliatory behavior on part of the other parent, and you were deprived of property rights, value to services and labor of your child, through no fault of your own. Thus, you were asking the court to terminate the support order simply because whatever deprives the parent of the right to the custody and services of the child without fault on his part relieves him from the duty to support the child. And there's the case right there. Now imagine the affidavit strategically written to support a parent's claim of manifest injustice in the proceedings of a non-absent parent stating how child support has ruined his or her life. That because of such high support payments, she was not able to keep a home, lost his or her car, then lost his or her job, which placed him or her in a high amount of arrearages, which cannot be discharged, which she will spend the next 100 months attempting to pay off according to the average pay rate of his career field. That's crazy. Shit, that's crazy. 100 months, that's almost, 60 months is 5 years. Damn. That's it's almost 10 years or close to, not too far from 10 years. That's crazy. Damn. I'm gonna stop right there. Yeah, I didn't even think it get like, I didn't even think child support people get that far behind. Like, that's crazy. Fuck. Anyway, let me jump back into this. Sorry about that. That for many nights she has had to choose between eating and giving up his or her last to his or her child's other parent to avoid failure to pay, contempt hearing, which could be place him or her in jail. I'm guessing they misworded this a little. Him, her in jail. That his or her failure to make ends meet and satisfy such support payments has affected his or her familiar relations greatly, friends and social life, because she has had to avoid social settings due to depression. that the parent has recently learned through case law that he has a property right in his child which cannot be deprived absent a finding that she abandoned or failed to provide his child necessaries, that she will continue to render his or her obligations privately, but that she is now being forced or coerced to obey a court order by state publicly and surrender nearly 70% of his or her income based on an obligation that he or she has never failed to adhere in nor pursue in, and that no court ever inquired in, whether he or she failed in this private venture due to any fault of his or her own, that he or she may very well be forced to continue this plight, not because he or she was an absent father who casted his child amongst the public deserving of such enforcement by the state, but merely because his claim today was a defense in the past that he or she could have used prior applicable to res judicata, even though he or she never, along with millions of other parents, never knew it was a defense available to him at the time of the prior hearing, strictly related to custody. It may be a little confusing for y'all. That's another reason why I'm gonna have to send y'all this book, because you're gonna have to read over this stuff again. The story and millions of ones similar are indeed manifest injustices that no doctrine should ever apply, let alone res judicata and estoppel. In my opinion, no court can ever rule against a well-articulated complaint arising from many parents across the nation in this manner. To do so, I believe, would provoke a revolution. That complaint is important, man. You got to know how to draft it, y'all. It's very important. The affidavit is important. The complaint is important. How you answer questions, all of that stuff is important. But the way you learn how to answer questions is you have to read the rules of evidence. You need to read case law in regards to the rules of evidence and in regards to your causes of actions. You need to learn how to allege allegations. As promised, could a father be consenting to losing his parental power via child support unknowingly by his consent to the child receiving the proceeds of his own labor? I believe this notion is easily defeated by stating the following in your motion. The parent did not knowingly, intentionally, nor willingly consent to the child receiving the proceeds of his or her labor. What way could a father be deprived of property rights that pre-existed the Constitution if there was no abandonment, failure to provide necessaries, consent to adoption, or cruel acts for which the state could assert its concern to intrude on those rights, which essentially is where the word interest derives from, the state's concern in your private affairs. The only other way that a father could be deprived of the value and services of the labor of his child is by his consent, which is exactly what this 1933 Georgia statute recognized. It says, and possibly other states to swiftly change. Okay, I see what he's saying. By consent to the child receiving his own proceeds, which shall be revocable at any time. Let me see. The only other way that a father could be deprived. I'm gonna have to go back and read that. This does not mean that all contracts are revocable. This 1933 statute, only states that at the time such rights were revocable. It could have been changed in modern case law. Indeed, contract law will control regardless of the state. This is only being brought up to discuss that there is some basis to believe that a father's consent is where he is being made to pay in a support order, which may shock the nation. Oh, that is crazy. This disturbingly fits the description of a million of fathers who currently are having their wages garnished or are making voluntary payments for the support of their children, even though they are non-custodial parents, meaning they do not have custody, who have been deprived of custody through no fault of their own. There can be no doubt but that the awarding of the custody of the child to the plaintiff in the decree of the divorce deprived the defendant of his right to her services. He could not command her services while the plaintiff was entitled to her custody. That's the Indiana Supreme Court case. In this regard, we are now forced to consider whether or not millions of fathers are in lawful theory voluntary paying child support and are under a secret contract that the state may use against you. Emphasis is used on the word lawful theory. Okay. Because consent these days is not the consent that the least sophisticated person would consider. Consent can be implied through conduct in lieu of words or signature. That is correct. He's right about that. Well, she or he is right about that. I don't know why I keep saying he. This may spike the minds of thousands of underground. The name is a corporation, trivia groups. However, this concerns neither those notions. This involves a simple understanding of contract law, just in case the defense of estoppel through contract arises, because once the courts and friend of the court realizes that your other claims are solid, they will throw everything they have at you. As you can see, around the time child support laws were being strengthened in Congress, justices of the court across the several states were setting the stage for their precedents that indeed may be used against you. The number of jurisdictions have recognized that a legally enforceable obligation to provide child support can be based upon parentage or contract. Wow. Now that is very, very interesting. Very interesting. A contract is a promise. A promise is a consideration that he's right. She or he is right. They are right. She's right. He right. She right. They right. Whatever. A contract is a promise. A promise is consideration. A promise is an intention to act or refrain from acting to justify a promise in understanding that a commitment has been made. A promise can be made from words or conduct. Damn sure can. I actually posted a case law. I think it was very similar to what I'm reading right now. That basically said that on my YouTube channel for y'all to see. A contract without consideration is void, widely known. The only thing here is to determine what the consideration was that operated in contract to form the consent to giving the proceeds of your labor to your child. Alleging in a complaint is simple by generally stating you lacked a knowing, willing, and intentional consent to the child receiving the proceeds of your own labor. Now the opposing side must tell you how you didn't lack a knowing, willing, and intentional consent. Okay. However, for the sake of diving deeper into consideration, I would like to discuss a few findings upon my research. I found this on Google. If one party was already obligated to do something, it doesn't qualify as consideration. Now that's very interesting. So, can a parent's consideration be based on an obligation to provide support to form the consent here? Consent to the child having your proceeds to deprive you of parental power. Here are case laws on this issue. Be mindful of your state statutes. In other words, can the consideration be based on moral obligation? Even if a moral obligation cannot be enforced, let's find out. The obligation of a parent to support a child has long been recognized in a majority of American jurisprudence as not only a moral obligation, but one that is legally enforceable. I hate using that word legally. Now, keeping this question in mind, read the indirect obscurity that was found in a 1998 Georgia Supreme Court case of right a case of right below that proves that a moral obligation cannot be enforced. This will prove important soon. This case ruled that a non-parent was obligated to pay support based on contract, but never mind its ruling, focus carefully on what was written related to moral obligations that I have provided below, which was written in a footnote. I will explain how the statements below operate in perfect harmony with what I will continue to call the holy grail of defenses to save America. Wright was also morally obligated to provide support for Newman's son. Merely because an obligation may not be capable of enforcement, is one not necessarily free to act in any way that he might choose. The non-legal obligations are not less sacrosanct. I'm guessing that's what that says, sacrosanct, merely because they may not be capable of legal enforcement. The moral, as opposed to legal dilemma faced by Wright lies within his constitutional heart and soul. He need have looked no further than to determine what he must do in this case. What he most do in this case. I thought that was an error, but I'm guessing it's not. What is that? All right, give me a second, y'all. Somebody calling me. All right, y'all. Sorry about that. Okay, where were we? I'm gonna read this again. Wright is also morally obligated to provide support for Newman's son. Merely because an obligation may not be capable of enforcement, one is not necessarily free to act in any way that he might choose. The non-legal obligations are no less sacrosanct merely because they may not be capable of legal enforcement. The moral, as opposed to legal dilemma faced by Wright, lies within his constitutional heart and soul. He need have looked no further than there to determine what he most do in this case. I'm guessing that's supposed to be must, because it looks like an error, but I don't know. This case provides that moral obligations cannot be enforced, which essentially proves indirectly that a court cannot force a legal obligation without depriving the parent of parental power. In other words, if the parent has not done any act that can be reasonably called a fault on his part, then he has not failed in his moral obligations. Only when he does so can the state force a legal obligation upon him. Oh, okay. Well, yeah, that makes sense. I'm thinking of moral obligation. I'm tripping. Why? Why? Because legal obligations can be enforced, and to close the moral obligation or consideration of one already obligated to do something could not be considered consideration in a contract until it was determined that the father essentially failed to provide necessaries or abandon his child. Fault on his part. This case law below, including all others above, clearly supports the proposition of this booklet. A non-absent parent who has not abandoned his child nor failed in his duties when he sought them custody cannot be forced to pay child support. This is a Supreme Court, Indiana. When a man abandons his child and casts it upon the public, he becomes liable for its support. But it is entirely impossible to treat a child as thus cast upon the public when the fact simply is that the mother has deserted the father and carried away the child and continues to support it. A father indeed has a moral obligation to provide for his child, but he cannot be legally forced to do so by the state and and the court and the child's mother cannot allege a contract due to your consenting in any regard, because one such consideration was based on a legal obligation in lieu of a moral. Includes I'm gonna have to send y'all this book, man, because I know some of this stuff is going over y'all's head, and it's kind of going over my head just a little, um, because I haven't studied this stuff. But some of it, it sounds pretty good. I'm seeing a lot of implicit equity principles in here, inclusive with what was just stated. The contract is unconscionable through unfair surprise. Okay, that makes sense. Three, substantive unconscionability, not being made aware that property rights were at stake. Four, for those solely forced or arrested and forced to sign an initial support order, or the contract was formed purely under duress. Here are sample wordings a father could include specifically in your motion to terminate based on these facts. One, at the time of the establishment of the support order, there was no lawful consideration to form a valid and enforceable contract to force the father to pay child support. The child support order is unconscionable through unfair surprise, substantive unconscionability, and procedural unconscionability. The only thing necessary after specifically stating these claims is for the father to now prove his claims either through discovery, injunction, a simple motion to stay enforcement pending the final determination of the motion to terminate, declaratory relief. Some samples are below. So let's see. Moving past this, you can think of even a more important reason that the doctrine of manifest injustice should apply to res judicata and estoppel defenses against claims that a father were deprived of value of services through no fault on his own. Thus, the custody order granting him visitation should be reversed, bringing him back to his original status at the time of the legitimation. Let's view the chart, then the author's notes. What this means is that not only will and can a father challenge his child support order through a motion to terminate, but he can challenge his custody order in the nature or form of a motion for equitable relief from the initial custody order granting visitation rights to the father. So manifest injustice doctrine, that must be an equitable an equitable remedy. Equity is just the vehicle the courts can use to bypass procedural issues and remedy an occurrence which, according to your claims, cannot be avoided and ought to be remedied to avoid a whirlwind of problems. Essentially, fathers must correct the consequence of an inaction of your Congress or state legislature to ensure these issues were resolved in the first place. Uh, we now that property, I'm guessing that's supposed to be, we know that property rights are involved in custody proceedings, but all across America, the right to the value and services of a child is unheard of. Considering this was an issue, put res judicata, the, considering this was an issue, put res judicata does not allow, and even if it does, the manifest, I'm guessing that's an error. Considering this was an issue, res judicata does not apply, and even if it does, the manifest injustice doctrine should apply. There can be no doubt but that the awarding of custody of the child to the plaintiff in the decree of divorce deprived the defendant of his right to her services. He could not command her services while the plaintiff was entitled to her custody. Okay, 1879. We also know that these property rights are parental power and cannot be lost absent fault on part of the parent. Accordingly, all a father needs to prove is that one, not only did the court not find his fault because it was not a matter in issue, nor put to issue in all of the circumstances in the custody hearing, but also that the parent had no fault on his part. Chronologically stating the three items, nor did any other cruel act entitling him to his child services. Okay, but how do parents prove they had no fault on their part at the time of the initial custody order? Some parents may be able to find the initial custody order that found facts and conclusions of law to show that this was never a matter issue. This was never a matter and issue. Some parents may utilize discovery and dispositions to prove that at the time of the initial custody order, he never relinquished nor had any fault on his part, not entitling him to his child services. In conjunction with discovery, parents could file an affidavit on the record stating such facts, including affidavits of witnesses. Some parents may have a mediated agreement, which in turn is prima facie evidence that such matter was not issue included with affidavits and discovery. Until majority, that means until the age of majority, a father is entitled to the services of child and the proceeds of his labor, and that this parental power is lost by voluntary contract, releasing the right to a third party; 2, by consenting to the adoption of the child by a third person; 3, by failure of the father to provide necessaries for the child, or his abandonment. That's from 1904, Georgia. In this instance, take the parent who states that at the time of the establishment of the custody order, that he never abandoned his or her child, never failed to provide necessaries, which in most cases is easily proved if the parent filed for custody to legitimize a child to get custody of a child he could not see because the other parent refused, because a parent is not entitled to even payment maintenance to a child he cannot obtain services for, but was instead pursuing said parental responsibility over the objection of the other parent who had no good reason to secret or keep the child away, and had only done so as a result of retaliatory behavior for a number of reasons applicable to the parent's situation. The issue in the new case is property rights, not custody. Although they are reciprocal, they are not necessarily the same thing, so res judicata would not apply, but even if it did, the manifest injustice doctrine applies. In the instance, imagine the affidavit of a parent stating how 96 hours a month has not only affected him mentally, but how it has affected his child mentally, keeping everything tied to the problems the custody order has brought, not spent, and the denial of property rights, services, and labor, not including statements that the other parent interferes with visitation, only how visitation has affected the child and the father. I think I see what they're saying here. That the child's mother or father has the superior claim to the services of the child, although he or she never relinquished nor had any fault on his or her part, and the court never considered the issue of whether there was any fault on his or her part. That the father is made inferior to not only the custody of his child without fault on his part, but inferior to religious decisions and educational decisions. Remembering that fault on his or her part is generally stating that a parent lost the right to the services and labor of his or her child, although not having done any of the 5 items that identified what the faults were in the chart on page 2. It's 1904. I think I'm going to read it again, though, because I really want to get this into people's heads. Until majority, the child remains under the control of the father, who is entitled to his services and proceeds of his labor. Civil Code 1910. So they've been new about this shit. If they codify, it seems like they've done what I think they do every damn where they codify principles. That's what they do. Until majority, a father is entitled to the services of his child and the proceeds of his labor, and that his parental power is lost by voluntary contract, releasing the right to a third party. 2, by consenting to the adoption of the child by a third person, by failure of the father to provide necessaries for his child or his abandonment. Okay. Let's see. As the case law states, parental power is lost by the failure of the father to provide necessaries for his child, adoption, or abandonment. This supports the prior mentioning of the verbiage without fault on his part. There can be no loss of parental power, loss to the services and proceeds of your child's labor, if the father has not abandoned nor failed to provide necessaries, maintenance. Without such a court finding, no parental power can be lost, meaning joint custody over nights spent cannot infringed in custody awards and cannot support, custody awards and child support cannot be ordered because no court can force a father to do something he already is doing, providing private maintenance. This does not mean that a mother can now utilize private maintenance as a clever way to place the father on support by asking for substantial private payments and then going to the court alleging the father refuses to pay such private payments. Thus, not only thus now must be legally forced legal obligation to pay child support because of his failure to pay private maintenance moral obligations. These payments must be reasonable according to the situation at hand, excluding alimony possibly. Argument can be made that a man cannot be forced to pay a woman's bills as a form of private maintenance for the child because she simply cannot do so. More importantly, if she alleges this is it could backfire as the father could now allege that he is entitled to full custody or substantially more time because the mother cannot provide for the child, even in his paying reasonable maintenance to his child while the child is in her custody. More importantly, before the state can even be concerned, which means have an interest, that is true, that's correct, and force parents to pay, the failure to provide private maintenance must somehow relate to the state of footing the bill. Hence why Title 4D was created for increased welfare roles, causing the government to pay the bills of absent fathers who have abandoned their responsibilities. As such, the prior justices and their rulings are in substantial conformity with the law and common sense. There can be no doubt that the awarding of custody of the child to the plaintiff mother in the decree of divorce deprived the father, the defendant, of his right to her custodies. To her servant. Well, I can't even read this shit. It's too early for this shit. I started reading this about 5 something this morning, y'all. Sorry about that. Let me take a deep breath. There can be no doubt but that the awarding of the custody of the child to the plaintiff, that would be the mother, in the decree of divorce deprived the defendant, that would be the father in this particular case, of his right to her services. He cannot command her services while the plaintiff was entitled to her custody. That's an implicit ruling. It doesn't have to be expressly said for it to actually happen. So that's essentially what happened. Perhaps one of the most significant claims made in this case, which will cause a shift in the entire family law industry across this nation, including the conversations we have surrounding this topic, is the fact that it is already proven in the case law above that a father cannot command services of his child if the mother is entitled to the child's custody, meaning that even if a mother and father has joint custody, if the father is not entitled to custody when the mother has their child in her care, he is not entitled to provide the support of the child. As you can possibly realize, this will make a mother's argument that a father failed to pay private maintenance while the child was in her care fruitless, as he is not obligated to provide maintenance to his child unless perhaps there was some implied arrangement to do so that he fully knew of and was not a mistake. What this means is that right now, if a father cannot command the services of his child because the mother has full custody or the majority of the custody, he is relieved from his obligation to provide support at those times. This all goes back to common sense argument that a father cannot be forced, cannot be forced or legally obligated to provide maintenance for a child that he does not have custody of, so long as his lack of custody is no fault of his own. I see exactly what they're saying now. Okay, that makes sense. That's the equitable, thing to do. But, uh, some men would disagree because the mothers and the fathers, they've talked it out and they've come to an agreement, some shit like that. So, but yeah, I do get what you're saying. A moral obligation cannot be enforced by law. However, a legal obligation can be enforced by law. By law means statute. We discussed this above, more on this below. A father who desires to be in his child's life and provide support but is prevented by the mother, forms no implied contract to pay the mother a sum of support. After a decree of divorce, either with or without an order for the custody of the children, there is no implied obligation on part of the father to pay child support. To pay support, let me see, to pay for support voluntarily, furnished by the mother to the children, while she asserts and maintains the right of their custody. In society, unless the father has in some way manifested his purpose to abandon them, or has refused to take them into his custody and render them a proper support. Let me see. I think I kind of misread that. Well, she maintains and asserts their right to the custody and society. Okay. Read this. Okay, so he's telling you to read this case. Read this entire case for those implied contracts arguments. 1889. Okay. There's the case right there. He's telling you the author is telling you to read. Ramsey versus Ramsey, 1889. Let's see, how long is the video right now? We're at 43 minutes. Okay, I'm going to do about an hour. So I'm going to do about 17 more minutes and that'll be it. In essence, unless the man did some act which formed the basis of providing support as alleged above, there can be no implied contract. Imagine the amount of men who wishes to have equal custody or full custody of their children, yet the mother, for no good reason other than she wants all the time or most of the time, says no. Or possibly her attorney, who seeks to prolong custody litigation for financial purposes by alleging BS claims that the father is unfit to increase his legal fees. In each instance, the father has made an express intention to get involved in his child's life, but because of the act of the mother or her representation, attorney, I'm not going to say lawyer, attorney, the answer is no. There can be no implied contract in those instances. As we know, the end result is to remove and strip these property rights. So consequently, for fathers who will just now be petitioning for custody, if your child's mother's attorney seeks to increase his or her legal fees by contesting joint custody for no good reason over a father's request for equal custody placements, joint custody, This can be utilized to support an argument that until custody is provided, you are relieved of child support, so long as there is no good reason to say no, of course. This is the genius of our law, checks and balances. That would be the equitable thing to do. The only thing a father needs to prove is that he has expressed an intention to engage in fatherhood, but only for the mother's acts he cannot. In other words, it all falls under and goes back to no fault of his own. Yep, that's right. When a man abandons his child and casts upon the public, he becomes liable for its support. But it is merely impossible to treat a child as thus cast upon the public when the fact simply is the mother has deserted the father and carried away the child and continues to support it. That's the same case from above. Reading above, this is entirely the case in America. The mother deserts the father with the child and or simply contests equal custody just because. I will now quote you a Georgia statute which also recognizes this property right. Property right. We have mentioned in this chapter, this property right we have mentioned in this chapter. However, as you will see, only the parent with custody of the child has the right to the child's services. Hence, the former argument why men may, if they feel necessary to terminate support simply because they have been deprived of their child's services. You may find this verbiage in many other states as well, as I have attempted to do so, however, are stuck with old books in my hindrance that I have told you. This is a 2020 statute. OCGA 19718, until a child reaches the age of 18. That's the age of majority. See how they're codifying these court opinions? The law of these court opinions. That's what they're doing. Or becomes emancipated, the child shall remain under the control of his or her parent, who are entitled to the child's services and proceeds of the child's labor. In the event that a court has awarded custody of the child to one parent, only the parent who has custody of the child is entitled to the child's services and the proceeds of the child's labor. Compare your own state laws for reference, then proceed in this chapter. I see some of these terms. I would have to go and read some of the statutes. At least in Alabama, I would have to go and read them just to see. But I don't doubt that she is wrong about any of this information. She seems to have done, the research. I have to talk to him again, but they seem to have done the research, thorough research at that. Let's see, what page? We on page 16. Where I stopped? I think on page 17. Did I stop? What are we on? We're on page 16. I'm probably going to stop on maybe page 17. I'm going to read this, and we'll stop on page 17. Let's see how much more time we got. Where we at? 48. Okay. As you have now seen and read, parents do have a property right to the services and labor of their children in custody proceedings. This is a fundamental interest, meaning this right is protected under the common law, if I'm not mistaken. Also, this statute lets the reader know that property right still exists and is recognized, however, only in the parent who has custody. Accordingly, this is the exact reason why custody is a fundamental interest, but not more so based on Troxel versus Grenville, and the custody claims in the context of its case for third parties, but based on fundamental interests related to property, rights to the services of labor of one's child. This interest and others that I will explain below can now be used to constitutionally protect your right to custody with your child. In other words, the bias every other weekend court cannot use a lesser standard, best interest, and order visitation. Yeah, he's right. She's right. Whoever, they're right. A privilege without proving that they have done so for substantial reasons under substantial protection. A damn sure right. So it changes the standard from best interest to there's a what was the other? It's either damn, what was the other standard? I forgot what it. I forgot. I think it was unfit or something like that. I don't know. I might be wrong. I might be wrong on that one. But there's a best interest standard. I forgot. I need to do some more research on it because I didn't forget. I didn't go read it again. In other words, you're invoking property rights entitles you to substantial protection. That's true because parents never invoke these rights. They essentially, according to maxims, sleep on these rights. Courts will be forced to use heightened standard protections, okay, that's right, as applied to you in order to remove parental power already inherent in parents, so long as you prove you are the parents. As you can clearly read above, unless parental power is lost, a parent is entitled to the child's services and labor, a property right. However, in the event a court has awarded custody to one parent, only that parent is entitled to the child's services. An important question now is this physical custody or a decision-making form of custody? The answer is very easy. A man cannot be entitled to the child's physical services if he's not entitled to the custody of the child to actually be physically in front of him to perform services. We learn that from the Indiana Supreme Court case above. The method of services is irrelevant. The only thing relevant is the right. However, prepare to argue with people trained to fool you. What you say? The only thing parents need to understand right now is that you now have a fundamental interest, a property right, to identify by articulating this right based on the cases that reference these rights and to invoke this right in custody proceedings. However, I must acknowledge that there are many men and women who believe who they are who believe they have a right to the care and custody of their children, which also must be protected. This liberty interest is true and may be used if the parent is facing off with a third party, such as the likes of CPS or grandparent, something like that. Yeah, CPS is another word for in Alabama they call it DHR, the Department of Human Resources. As it relates to parents dealing with third parties, such as CPS or DFACS, I wonder what that stands for. I know that's an acronym for something. Your fundamental interest remains the right to the care, custody, and control of the child, which must be invoked, including your right to remain silent. Continuing, however, many parents may be quite surprised to what judges already know as it relates to non-third party controversies, meaning mother and parents disputes. That is, the parents' right to care, custody, and control of their child are deemed offset in contesting custody issues. Didn't know that. Case law. While parents do have the natural right to care and custody of their children, the honored court concluded this does not mean that parents have a fundamental right to equal placement periods after divorce. That must be a footnote, 96. The reason Arnold and other courts have suggested is that a mediating role by the state is necessary to resolve what otherwise would be a deadlock of conflicting rights. Writing that the father claimant had not demonstrated why, following a divorce between parents, the state does not have the right to arbitrate and dispute those parents. Let me see. The state does not have the right to arbitrate any dispute those parents may have over what happens to their children. Important for research for the reader. As you read above, this case is one of the top cases that an appellate court would quote when a parent asserts solely that he has a fundamental right to the care, custody, and control of his child without invoking property rights mentioned above. Courts would deem these rights offset. In the context of case law above, the honored court concluded that the state had a mediating role to resolve the deadlock of conflicting rights. So they're acting as a mediator, some sort of arbitration type thing or something like that. Let me see where we at. How much more time we have? About 5 more minutes. Conflicting rights, meaning the father or mother's fundamental right to care, custody, and control of their children, canceled each other out when the case was a contest deciding who would get the child. One would understand, yeah, that would make sense. I see exactly what they're saying now. That would make sense because if this is the father's child biologically, and if this is the mother's child biologically, and they've also been adjudicated to be the father has also been adjudicated to be the father or whatever, then he would be entitled. He has a fundamental right to the care, custody, and control, of his child, and so does the mother also. So how would you remedy that situation? What is the equitable thing to do? What is the fair and just thing to do in a situation like that? That makes sense. One would understand why the state could assume a married couple in a divorce case could assume a mediating role. However, what about unwed parents? The most significant thing said in this case, however, is not that the state did not have a right to arbitrate disputes of the parents of what happens with their children. It stated he had not demonstrated why, leaving the door open for someone who indeed demonstrate. Keep reading. Okay, this is getting good. For other cases holding that the offsetting rights of parents display strict scrutiny protection of fundamental rights and allows, I knew it was some. That's the other standard right there. Strict scrutiny. When they start infringing on your private rights, strict scrutiny is the standard, if I'm not mistaken. Let's see. Of fundamental rights and allows use of a best interest standard to resolve custody disputes. And they're citing the cases right here, rejecting father's claim that the use of best interest standard violated his fundamental parental rights and observing that since both Robert and Linda are the natural parents of the children, there is no presumption that the best interests of the children are presumed. Let me see. There is no presumption that the best interests of the children are served by granting custody to either of them. Whoa, now that's interesting, but that makes sense to me though, because they're both the natural parents. I think I'm gonna let me see how much more we got. I'm gonna stop right here on 17, y'all, and that'll be the end of this video. Important to note, I recall a parent making an argument that one deliberate parent who himself or herself alone causes conflict cannot create a fact situation into which fundamental interests can be offset or cancel each other out. This is because if such was the case, then a parent need not but to purposely cause a controversy and conflict in order to offset fundamental interests of the parent under the Constitution. This is unfair to the other parent who never started such a conflict and sought to remedy it, but only for the wrongdoer, his fundamental liberties are offset. Okay. In this instance, with this argument, a parent could demonstrate, as the Honor Court stated above, in my opinion, the offsetting of rights is nothing more than a bland excuse to display strict scrutiny for no other good reason or excuse other than there were no other good reasons or excuses to use. Regardless, the only thing a parent must do is articulate a fundamental interest that must be protected in custody proceedings to essentially protect their children because the states, as we have seen, refuse to do so for financial purposes. The author is right. Let me go back and read that again. Regardless, the only thing a parent must do is articulate a fundamental interest, meaning like some sort of property right. If there's a custody dispute, whether any type of dispute, doesn't matter what it is. But we're gonna be talking about child custody here. So if there's a dispute over custody, then you would have to find an argument that has merit in law. Uh, for example, the one that the author is making in this book, that if you're deprived of the custody of your child, you're going to be implicitly deprived of the right to your child's services and labor, which is a property, which is a property right. You're like, for example, your labor, your own personal labor belongs to you. That's property. Rights are property, just to let y'all know. Even though you cannot see rights, they're not tangible. They're like it's like they only exist in the mind, or so to speak. They are property. And like, for example, you have a right to use property. You have a right to own property, and you have like let me rephrase that. You have a right to own property, and you have a right to use that property that you own in almost in any manner that you see fit. See what I'm saying? But if they start infringing on that, telling you how you're supposed to use this property, then that is a violation because they're infringing on your property rights, your private rights. That's a that's a violation of the Constitution. They're infringing on your rights. Oh boy, it's too early for this. Where did I start off? Where did I stop at? Okay, I stopped right here. So I'm going to start on the next sentence. You can allege as many of these rights as you can. In custody proceedings, the grant of custody becomes intertwined with child support, which then manifests the pecuniary interest. Pecuniary means financial interest. This means just financial, something dealing with so-called money, which causes the state to waive the hand at joint custody requests of the parent. However, that hand is restricted in movement under the Constitution when fundamental rights are invoked only, notwithstanding an argument that a parent was never absent nor lacked in providing maintenance to protect his pecuniary interests from an unjust transfer of wealth arising from financial incentivized child support orders and piercing of property rights. If a parent articulates and utilizes these arguments correctly in these proceedings, it will indeed bring you under the protection of the Constitution versus no protection at all. They are right when they say that. What America must do now is heighten the interest to protect an encroaching court whom all have seen whom all have seemed to wipe their asses with the Constitution. As you can see, for now, courts have precedents to offset and displace strict scrutiny protection of fundamental rights in mother-father's custody contest proceedings, which allows the well-known bias best interest standard to take its place. As such, there is no heightened protection. We now can pinpoint which then allows a court to grant every other weekend visitation. I never knew some of this stuff either. Visitation or privileges, not fundamental rights. That is correct. That is 100% correct. Attorneys are failing, if not outright refusing or assisting this injustice. Parents and lawyers not only do not utilize property rights in the right to services and labor of children, property rights, but they also do not. And if we're over an hour, I'm gonna go ahead and we're already over an hour. All right, I'll pick up on page 18 tomorrow. That's what I'll do. All right, y'all. That will be the end of this video. Sorry for stumbling over my words from time to time, but we all do that. My mind gets like that when I get tired anyway. But anyway, that'll be the end of this video. The Supreme Litigant is out. Peace.